Welcome, everyone. I hope you're enjoying your day so far. Thank you for spending your time with us on this webinar today. My name is Katherine Grout. I'm an attorney here at Copenbarger Law Firm, practicing in our business and tax department. I'm co-presenting today with Elaine Alston in our litigation department, and we'll be presenting some material for in real estate for tenants and landlords. If you have any questions, feel free to put them in the chat. We will potentially have some time for Q&A at the end of this webinar. We may be able to answer some questions, though if there are questions that are too specific, case dependent, or just not something that we can answer here today, we will follow up with you afterwards. So if you've attended any of our webinars recently, you've probably seen most of these faces here. A couple of them have been added, myself included, this past year. But we actually have a couple of new faces that aren't on this screen today, too. We have two new attorneys that just joined us this month. So in future webinars, you will see their faces up on this screen. I want to highlight this and kind of the breadth of attorneys that we have here and the scope of work that we can cover, because one of the great benefits of working with Copenbarger is this full coverage of planning and protection that we can provide to families. This scope of experience really better and best serves you. The attorneys here at Copenbarger not only focus on estate planning, but we also have dedicated attorneys ready to provide you with more advanced planning and tax advice. We also have myself in our business and tax department. We can help you form or operate and manage your business, and we can provide some general counseling for your business operations. We also have a very large and robust estate administration department that can guide you through any of your trust administration. So whether or not you've passed and your loved ones are now needing to administer your trust, or if you're trying to administer the trust of another, our estate administration department can help. And then, as we have Elaine on the call today, she represents our litigation department, helps us navigate this tumultuous area of the court systems that I don't begin to navigate myself. She has 30 plus years experience. She fiercely defends her clients in court. She's a phenomenal asset. So I'm really happy that she's on the call with us today. So full scope of support and protection that we can provide you. We always try to avoid court with some of the advanced planning, but we all know court is sometimes, and litigation is sometimes entirely unavoidable. And here we have Elaine to support us and to support you. So with a variety of legal services, we can actually handle everything with you, and we don't have to outsource some of these services, some of these more nuanced services. We can provide it all in-house. And I love this slide because truly we wouldn't be anywhere without our support staff, without our departments, paralegals, legal assistants, everyone who handles our business operations, our firm's operations, helps us stay running and helps get your questions answered efficiently, helps direct your questions appropriately, gets you scheduled in to see an attorney. All of those people are pictured here, and we wouldn't be where we are today without them. So we really appreciate our full staff. And our locations, another great benefit of working with Copenbarger is we have offices in many metropolitan hubs throughout the state of California. Now, even if you are not located next to one of these hubs or one of these offices, we can still do most or nearly all of our legal services remotely via Zoom, whether it's because you are not next to one of these locations, not nearby, it's too far of a distance to meet with us in person, or if it's simply too difficult for you to come in person, we can set up a Zoom or a phone call to handle all of our legal services remotely as well. So we will accommodate your needs appropriately. Okay, and now let's get into some of the actual meat of today's topic. So at first, Elaine's gonna start us off, and she's gonna provide some information on real estate liability that we tend to see, then anti-discrimination laws, cover eviction and compliance as well. And then I'm gonna take it over and switch gears and talk about how we protect against some of those liabilities from the landlord perspective and utilize one of the primary vehicles to provide protection, which is an LLC. So with that, I'll let Elaine take it away.
Good afternoon, everyone. Owning real estate, especially rental property, exposes property owners to liabilities to both the public and to the tenants. And the purpose of this webinar, as I see it, is to help landlords basically avoid some of the liability and to sew up what people think of as the deep pockets. We don't want people getting into any of the pockets too deep. And that's one of the reasons we'll be discussing with you the limited liability companies, which is a way to protect other assets other than your rental properties. But your first line of defense is the rental agreement. Katherine, if you wouldn't mind, there we go. The rental agreement defines the obligations and duties of each party. It determines who can live on the premises. It determines what the property can be used for. And when I say the uses, when you think of liability, there's a lot of liability if your rental property is being used to store hazardous materials. There's a lot of liability that comes about if you're allowing people to repair automobiles on the premises, if you're allowing people to either store or use poisons on the property. There's liability if the property is going to be used as a daycare facility. And I tell you, if a child is harmed on your property, they're going to be looking for somebody with money, and that includes both your friends, it includes tenants, and anyone else in the community. Think about things such as insurance. If you need to have the tenant insure the property, you want to be named as an additional insured if they're taking on some more dangerous activities. The rental agreement will define who pays certain expenses, and it will also allow you to have rules and regulations. Those rules and regulations can be included in the rental agreement, or they can be in a separate document which you refer to and incorporate into your rental agreements. The rental agreements can warn about dangers. For instance, if you have a community, an apartment building, or perhaps even just a single family home, but it has a pool, you probably want to include in your rental agreement statements regarding warning that children can drown in pools, that you shouldn't swim alone, it's keeping gates closed. Those are the type of warnings you may wish to include in your rental agreement. Now, I want to tell you that even if you warn of certain dangers, if your property is in itself a danger, you're not going to be able to escape liability merely because you say in your rental agreement that there exists the danger. For instance, if you've dug a 20-foot hole into the backyard, you're not going to be able to just escape liability by saying, oh, by the way, there's a 20-foot hole in the backyard. You're going to have to take care of that. The rental agreements can be customized, so you are not confined to the rental agreements that are prepared by some of the rental organizations. You can certainly have those modified. Be sure, though, if you're modifying agreements, that you know what the terms mean and that you are agreeing to those terms. If you don't agree with the terms, don't sign it. That goes for landlords and tenants. A rental agreement can also define how you're going to resolve disputes. Many times the rental agreement will include provisions for arbitration. And arbitration does a lot in the sense of it stops a runaway jury. It often stops publicity and keeps things private. They can be less expensive. Sometimes they're just as expensive, but they can be. They can be resolved faster for some civil matters. But when it comes to eviction processes, the arbitration procedure will not be as fast. So many rental agreements will exclude the issue of possession of the property from the arbitration provisions. So keep that in mind. The eviction processes in the court move much faster. So in thinking about as a line of defense for liability is making sure that your rental agreement covers all the things that you want it to cover. If you don't understand it, don't sign it. I would advise, contacting an attorney, going through a rental agreement. If the tenant wants to add something to the rental agreement, there's nothing wrong with that. But as a landlord, you need to make sure you fully and completely understand what it is that's being added. There's a new area of liability, and this is the security deposits. The security deposit law was revised so that it would change January 31, 2024 of this year. Then they went back through and said, no, we're going to make some more changes. And that became effective July 1, 24. And then on September 19th, they made more changes, and that became effective immediately. The intent of the legislature in issuing the new security deposit law is to prevent landlords from subsidizing their improvements to the rental properties with the former tenant's security money. I'm going to go into a lot more depth on this in my webinar that's going to take place on October 30th. But I want to tell you a little bit now, because as it's a new law, it is going to be an area ripe for basically landlords making mistakes, not intentional mistakes, but making mistakes, and tenants being able to dig into the pockets of the landlord to get reform for that. Currently, almost all landlords can only request 1 month's rent as security. There's a few exceptions, and the exceptions are if there's a natural person, which includes trusts, but as a natural person, and that natural person doesn't own more than 2 residential properties and no more than 4 dwelling units on each of those. So in other words, it's not for a person who owns an apartment building. It's intended if you have a couple of homes that you're renting out, or perhaps a couple of duplexes that you're renting out. Then at that point in time, they're allowed to ask for 2 months rent. The landlord must not, in requesting a security deposit, be thinking they were going to get anything back for wear and tear. Wear and tear and cumulative wear and tear is something that the landlord just has to eat. So you won't be able to recover for the footprints that go into the carpet. You won't be able to recover for certain marks on counters and cupboards, because that's just something that's ordinary wear and tear. You are not allowed to ask any more for professional carpet cleaning or other professional cleaning services unless there has been extreme damage to the property. So if you go in and they've had a pet in there and it's got pet urine all over the carpet, yes, you could get professional cleaning, but you can't just ask for professional cleaning because you're moving somebody new in. The law also now gives the tenant the right to request an inspection at least 2 weeks before they're being asked to leave or are voluntarily leaving the property. That means as a landlord, you have to come in and give them an estimate and tell them what items need to be corrected, so they have the opportunity to cure. There's a special notice that you have to give. And after the notice is given and after the inspection, the tenant will have that period of time from the date that the inspection goes to the date when they vacate to make and cure the problems. After the inspection, there has to be a written document setting forth all the things that are wrong and an estimate of what it's going to cost to repair, so that the tenant can make a educated decision as to whether or not to go forward and repair. As I said, we will go into a lot more detail on May 30th of those requirements. Now, beginning in July of next year, the landlord shall, and it's not a may, but shall take photos of the unit before the inception of the tenancy. That's to ensure that the tenants are not being made to fix something that was already broken and any damage that existed. Beginning April of next year, the landlord shall take photos of the unit within a reasonable time after possession is returned, but prior to the repairs being made. So that's a way for documentation of the condition of the property after the tenant left, so that if there's a challenge for the landlord can say, well, here's the picture of the carpet, see how filthy it is, and it took us this much to put it back into normal condition. Or it gives the tenant the opportunity to say, look, those are the pictures. You can see that the carpet has nothing but just ordinary wear and tear. There's no tear, there's not any horrible stains and the like on the property. Within 21 days after a tenant moves out, then the landlord must furnish the tenant with an itemized statement of all the things that they had to fix and the costs. And the statute goes into a lot of depth as to what receipts, what copies of documents, what information has to be provided to the tenant with that final amount. And as I say, we'll talk about that in a lot more detail. But you need to know that the statute itself has penalties imposed for a bad faith claim or a violation of the statute, which can subject the landlord up to statutory damages to twice the security deposit, in addition to any actual damages. And so we need to be very careful in following the code section. Now, another issue that we have is a liability for animals. I want to define this very clearly. Animals do not include your service pets. So there's a difference between having a service animal that comes in and performs a service and having a pet. I recognize, and I think you do too, that they're animals, but what we're allowed to dictate as a landlord, it varies drastically. So if you have pet deposits and security deposits for pets, that doesn't apply to service animals. So everything I'm going to be talking about now is going towards pets. We have traditionally said that a landlord can require a pet deposit. There is some gray area now in the law, because the way the section on security deposits reads is it says security deposits can only be collected for a number of items. Pet deposit is not listed there. However, in a new bill that's up before the legislature, they are proposing to change once again the security deposit and will add that the pet deposit would be one of the items listed. So it tends to reflect that perhaps we can still be asking for a pet deposit. What I'm going to tell landlords now is not to request high pet security deposits, because that may be deemed as improper and a violation of the rental code. Landlords can regulate the size of the pet, and in most jurisdictions, there's often breeds that can be restricted. You can limit the number of pets. You can dictate waste removal. You can put on limits as to what behaviors you feel appropriate. You can ask for vaccinations and registrations. Now, landlords often will require pet profiles so they know what pets are there and what they have, age, size, breed, requiring proof of pet licenses and vaccinations. Some landlords will take pictures of pets. Some will make sure that it's clear in their rules and regulations as to certain areas in their community where the animals may go and where they may not go. Landlords have to be careful, though, in making sure in they making these rules that they don't make them so restrictive that it's impossible for them to have a pet. So in other words, you can't say you can have a pet in your house, but you can't walk the pet anywhere on the grounds of the community. So you have to make sure that the bathroom requirements are being met for the animal. And imposing monthly or weekly inspections of inside units regarding pets is also something that has been determined to be very detrimental to tenants and therefore exposing landlords to liability. Usually, the law does not allow for the pets to undergo special treatments like as declawing or debarking. Now, landlords do have liability exposure for having some pets in the property. It is if the landlord knows that the dog or other animal there is aggressive or has caused damage to somebody, then if they knowingly allow someone to continue to keep a vicious animal, then they too have liability. If Fido has never done anything, and Fido's a cute little poodle, and you as a landlord have said that's fine. But if you find out that Fido has been running down the street and biting all children's ankles and hurting them, then the obligation of the landlord is to give a notice to have the person remove the pet or to control the pet. And if the landlord doesn't do this or doesn't enforce it by making sure that the animal is controlled, the landlord will most likely be nailed for liability. Because again, if somebody gets hurt, they're looking for deep pockets, and tenants, generally speaking, aren't the ones that have these multi-million-dollar properties. So they'll be looking to the landlord. Now, another area that landlords can get in trouble with is for violating the anti-discrimination laws. And the anti-discrimination laws, there's the federal and the California Fair Housing and Employment. Where you're not allowed to discriminate is based upon race, color, religion, sex, familial status, that's like marital status, national origin, ancestry, disability, medical condition, and source of income. And if you discriminate, there's huge penalties that come into effect if you have done so. So one of the things you have to be very careful is that you treat all applicants for your rental properties exactly the same. It doesn't matter if a person shows up as in a wheelchair, a single mom, a woman wearing a hijab, a blind person, someone who is gay. You cannot discriminate against these people. So if somebody comes to apply to your property, you go through the same language as you would with anyone else. Things that can be found to be discriminatory often are done without really the intent to be discriminatory. For instance, if you had a woman and a man come in and they've got 6 or 7 children under the ages of about 7, a property manager saying, well, we don't really have places for children to play here. There's nowhere safe. The street is very busy. That would be seen as discriminatory against somebody with a familial status because they're got all these children. So again, it's just a case of looking at the situation and making sure that what is said is said to everybody the same. If a person asks, do you have a park for children to play in? Your answer has to be truthful, yes or no. But you don't volunteer that to them just because they appear with children. And I want to warn you that there are testers. There are people who literally, their whole goal is to go out and catch you in making some discriminatory remark. These are people who fake their appearances. They will show up as perhaps a Black woman and a white man. They present themselves to you as a married couple, or perhaps a couple that's cohabitating. They don't have to be. They can just be random people who have decided they're going to show up and test you. And if you say anything or do anything that gives them a reason to sue you, they will, because that's why they're there, to test you. And you can't ask somebody, are you a tester? That's not going to work. So again, I want you to caution you that there's a lot of liability that can be imposed. And when I say a lot of liability, there's the actual damages, punitive damage, statutory fines, there's their attorney's fees, and then you can be hit with an injunction. The California Fair Housing Development has a sort of standard. It's a $10,000 penalty. That's the starting point. Then if you're found to have had a second violation, it goes up to almost 100,000 immediately. So again, I'm just cautioning you to make sure that you don't act in a discriminatory fashion. And if you've got some questions on that, I'll go a little bit more depth on May 30th. I'm also available to chat with you about that at any time. Now, a lot of times there's disputes between landlords and tenants, and ultimately it ends up in an eviction process. The eviction process under the Civil Code and the Code of Civil Procedure is a deliberate scheme to make sure that we can turn over property quickly so that things don't get bogged down in trials for 2 or 3 years as regular civil litigation matters. But in order to do so, the landlord must follow the law just very, very carefully. And if it's not followed, the tenant can follow up with litigation for wrongful termination. So what you want to be is very careful in doing the eviction process correctly. And that basically means, for most landlords, is you need to work with an attorney. You have to make sure that your notice is clear and concise, accurate. If you have the rent down as 300, it needs to be 300. I have seen people lose eviction cases when the amount outstanding was $300 and they put $301 down. So when there was that dollar or that penny difference, it can make or break a case. So you have to make sure it's accurate, because if it's not accurate, you've asked for too much, you're now attempting to evict a tenant for wrongful purposes, getting more money than you're entitled to, even if it was unintentional. Now, there are new laws that have come out with respect to the reasons you can terminate, and I will go through those on May 30th much more clearly, but there's for cause, and then there's not for cause. The for causes are if the tenant has done something wrong. There's a breach, they have not paid the rent, or they sublet to people that you haven't authorized. That area would be your fault. Then there's the no fault, and no faults are when a landlord wants to take the property off of the market, when there's major renovations that have to be done and nobody can live in the property when that's going on. And as I said, we will go through that in much more detail. But if you violate the new law, then again, there's the actual damages, attorney's fees and costs, treble damages for willful fraud, oppression, and malice, punitive damages, and even in some circumstances, the attorney general may step in. So the cautionary tale that I have is to make sure that you know what your rights are, you go through and prepare a proper notice, you properly serve it, you make sure the tenant has the required time to cure, and that you make sure that when you go to court, you have the proof that you need as to the amounts that are outstanding or the behavior. Because if you don't and you lose, or if the tenant can show that you were acting in bad faith, there is a lot of damages and liability that comes about. The next and last section that I want to talk to you about is the compliance with state and local laws, regulation, ordinances. There's a lot of liability that comes about if you don't comply. And in reading the statutes, reading the regulations, you can be exposed to penalties, fines, and other forms of liability. Reading the regulations, look for things that say the landlord shall or property owners shall. And I'm just going to give you one example, and we can talk about this. But for example, if you have a swimming pool, there are a lot of laws that govern what you are allowed to do and not do when you have a swimming pool in an apartment complex or even in your own home. There's federal law, there's state law, there's county law, there's cities laws of regulations, ordinances. For instance, there's certain types of drains that you must have. Gates and fences, and the regulations talk about the height of the gate, talk about the height of the fence, talk about which way the gates open and close. There are certain signs that you have to have up on a pool. There are handicapped access that you have, which goes again into the anti-discrimination area. So I want to caution you and let you know that that's where liability is imposed. Now, I'm going to turn this over to Katherine in just a moment, and she's going to talk to you about another line of defense. And the other line of defense is limited liability companies. And I have been litigating cases for a long time, for 30-something years. And when property is held by a limited liability company, it is much more difficult for the tenants or other public people to pierce that limited liability company and go after other assets. So as a general rule, I recommend that people have each of their properties in a separate limited liability company. And that way, if you have a mobile home park and then you own an apartment building, they can't get to the mobile home park if what was supposedly done wrong was in the apartment complex. I also discuss with people that if you hire a property manager and you have a separate property management company, there are sometimes when that property management company would be liable and not the property owner, depending on the type of conduct. And therefore, if you're a property owner that has multiple pieces of property, you may want to have a separate LLC if you're doing your own management as a management company, and then have your properties each in separate limited liability companies. There's ways that people can pierce through if you don't have them financed right, and Katherine's going to go through with some of the obligations that you have. But these are protections that a landlord can have to make sure that not every piece of property that they own is subject to the liability imposed or a judgment obtained at one property. So Katherine, at this point, I believe you will be discussing a few issues with everyone.
Yeah, thank you so much, Elaine. That was, I can't wait to watch the deep dive next week into more of the legal changes. This was a nice preview of that. So really excited about that content coming forward. But let me go ahead and say, I'm going to start off with a couple of potential case studies, and some of these will sound kind of common, especially if you are a current landlord or you have really any experience in rental properties, even as a tenant. let's assume that you have followed, you've watched Elaine's webinar, you've followed the law to the T, you've followed all of that. What liability exposure do you still have? And so a common big ticket item that we still see, I'm going to highlight in these cases, and that's that personal injury that you really can't account for, even if you're following all of the law to the T. So I'm going to give a couple quick examples just so that we can have this in the back of our mind as we talk about some of this exposure and risk. So let's say you're a landlord and you have a tenant, longtime tenant. They've been a great tenant to you, but they have a big, they have a big 50th birthday bash that they're putting on, and it is quite an event. People get a little bit rowdy. And one of your tenant falls through some of the railing on the back deck. They sustain serious injuries. Those injuries require surgery, extended hospitalization, rehabilitation, maybe even long-term issues that are detrimental and impact their ability to work. And then the tenant files a lawsuit against you. You own the property directly in this example. What types of damages are we looking at? Just to name a couple, some of those medical expenses, lost wages, long-term pain and suffering, because you owned and managed the rental property as an individual, your personal assets could be punctured and subject to that liability or that legal claim. Another example, let's say you have a separate property and your tenant has a dog. This dog may be perfectly well behaved, well trained, but I mean, dogs are animals that can behave erratically in the event of a threat. And let's say this dog, Fido, sees a threatening dog or sees a threatening walker, maybe with a dog, maybe a dog walker, right just outside, or maybe there's a solicitor and the door isn't properly latched and Fido escapes, bites the walker. Same thing we're seeing. A high injury claim, high medical expenses. We talk about these types of damages because we really, they could be exorbitant. They could be very large. Lost wages. Maybe this time it's emotional distress too. A dog attack can be a very pivotal and stressful and traumatizing event in a person's life. What's the result? Again, you own the property directly. You manage the property directly with your tenant. Your personal assets can be punctured and subject to this legal claim that is now decimating your nest egg that you've accrued. One more example I'm going to go through. Let's say we're going to start off here where you don't own this property directly. You did set up an LLC and you managed and owned the property through this LLC successfully and independently from you, but you did own the LLC. You have, so this LLC owns this property. This property has a beautiful oak tree, but it is just, the roots are creeping up, lifting up the walkway cement, and your tenant trips and falls on this now uneven pavement that was once even when you first put in this walkway. Again, the same. We could see any number of serious injuries that happen here. Hospitalizations, rehabilitation, long-term issues, lost wages, all the same types of extreme damages that we could see. But now, because the LLC was independently owned and because the LLC held that property, your personal assets weren't touched. And why? How? If you are familiar at all with the corporate liability shield, the LLC carries this same shield. So an LLC actually creates a legal barrier that separates your personal assets from the assets that are owned and managed by the LLC. This shield can then protect any assets that you do not fund into this LLC. So that could include your personal bank accounts, your savings accounts, your personal brokerage or investment accounts, retirement accounts, vehicles, and your primary residence. Another thing we want to stress is your primary residence is your personal asset that could be subject to a litigation claim, of a personal injury litigation claim like this. If you have this rental property in an LLC and you've successfully shielded it with this LLC legal barrier, then your primary residence can be saved. And I want to talk a little bit about insurance, because insurance is great, and I shouldn't, LLC versus umbrella insurance really isn't the best. It really should be LLC and, because they're both good, but there are certain limitations. So as a landlord, you may have gotten an umbrella insurance policy to kind of cover you in some of this risk. But I want to emphasize that this LLC structure, this legal shield, does offer more extensive, stronger, better coverage. And think about, your coverage limits with your insurance. Think about damage type limitations from your insurer. Also think about the fact that you are just subject to the whims of your insurer. You could lose coverage. Your coverage cost could increase. The LLC doesn't have any of these limitations. It fully insulates your personal assets. So when do you need an LLC? Well, when would something like this occur? Essentially, once you start renting out a property, maybe even before you've bought that property, and we'll talk about that a little bit more, you can see benefits from an LLC. You'll want the LLC structured and formed and operating your rental business before the accident happens. Possibly before you purchase the property, because there's some tax benefits, before you start earning a profit that is then transferred into the LLC as an LLC asset. So I think I love that Elaine is on this with me, because she can speak from real experience in court as a litigant, and she knows the risk. She's seen the risk. So I probably didn't even need to do much selling on my part about how an LLC can shield you. But I do want to highlight, this is always, as with every decision we make in life, it's going to be, what's the cost to? I need to understand what it's going to be. What is the cost as direct cost, or what is the time cost? How much management is this going to be? And I want you to rest assured knowing that an LLC is actually a very simple to form and simple to maintain and manage solution. And we can help with both parts of first creating the LLC and then managing it, maintaining it, keeping up filings. Copenbarger, we can help you with both of those processes. So in creating the rental LLC, as you would with any, you'll file with the state that you're organizing in. Typically, it's going to be wherever the property is located, and it will be that state, but there is variability there depending on your needs. And then you'll have to file any federal and state reports. Most states have annual reports that you need to file. California has every other. You'll also need to, in the formation process, draft an operating agreement. And we of course can draft an operating agreement. And I'll highlight this more later, but I do highly recommend that an operating agreement is drafted by an attorney, because it is specific to how you need to manage this business. Elaine, I see you got off mute. Go ahead.
I can't tell you enough that you need to make sure that you have a very clear and concise operating agreement. I have litigated several cases between the members of limited liability companies over disagreements as to what's required in and is for the company. So it is not something that I would just take out of off online and think that whatever you found online would work for you. Those are the ones that I end up litigating. So just a caution there.
Thank you. Yeah, an operating agreement is actually going to define how you can manage your business. So if it deviates in any way, if it's different from what you need and it doesn't reflect your needs, it will not serve you. And you need to make sure that it works with your situation. So the operating agreement, execute it, and then you'll want to fund your LLC with the rental property itself. So you will deed your property into the LLC. This is a very simple, this is the most basic workflow that we could have, right? Then maintaining the LLC, I mentioned previously, some states will require annual or periodic reports. You'll also, one key element of being able to maintain this legal barrier, this shield, is that you are operating the LLC as a separate legal entity, which means it has its own accounting. It has its own bank account. Funds flow into the LLC. You can also take out funds, but you need to make sure that you're doing so appropriately so that the LLC maintains operating expenses, operating funds. So it is not, it can be simple, but definitely work with an attorney to just understand what needs to happen on a fundamental level so that we can maintain this legal shield for you. Once this legal shield, if you do not appropriately keep your LLC funded, there's the potential to pierce that shield that you've created initially because you are not maintaining it appropriately. And you're just the alter ego of this separate entity. Go ahead, Elaine.
Again, if they're looking and you've got a judgment against the piece of property, if that property has had every dime that it's ever made sucked out of it, and that every time there's an expense, the owners come back in and put in a few dollars to cover that, they're going to find that the LLC was not properly funded. Doesn't mean you don't take dividends. It doesn't mean you don't take money out. But if every dime comes out and there's no money in the bank account, they're going to find that you haven't properly funded it. It's just a cautionary tale.
Yeah, thank you. But as long as we've done, as long as we've run this appropriately, we've maintained adequate funds, we can maintain this very broad and robust protection for all of your personal assets. This next slide is just a highlight of kind of some of the advantages. In general, the takeaway I want you to have is that an LLC is very flexible and easy to manage. There's also a lot of flexibility in how you structure it from a tax perspective that varies, and we'll actually go into this a little bit just shortly. It's going to have that same liability protection as a standard corporation would too, and a corporation's owners. And we already touched on this, but it's worth repeating again and again. You know, do avoid at all costs. Yes, there are cheap solutions online available to you to get this up and running, but if it's not done correctly, it was worthless to you. So make sure it's done correctly. Otherwise, there was no point in doing it at all, creating this LLC. So cheaper options are just going to cost you more down the road because you've paid for this service that actually doesn't work and it doesn't shield you. So please consult an attorney. when creating an LLC for your rental property to make sure it's done correctly. And then last, or one of the last main topics I'm going to talk about today are just briefly some of the tax advantages of an LLC. It will vary depending on how you structure it or how it's structured. Excuse me, a single member LLC, that's going to be one single owner, or it could even be a couple in a community property state like California that owns it wholly. It's actually just going to be treated as a disregarded entity for tax purposes. So it would be the same as a sole proprietor. There's no need to file a separate tax return. You could also see special deductions. Then a multi-member LLC. So I should take a step back and say, if you're not familiar with the term member, it equates to just an owner. So a member is an owner of a portion or all of the LLC. So multi-member LLC could be siblings, or could be individuals that are just not related. That's going to have another separate tax advantage, which is this flexible taxation structure. So one key element of an LLC is that you can elect to be taxed as either a partnership or a corporation. And for the purposes of landlords, a partnership is often the best option. So partnership taxation will mean there's no gains or loss on distributions of property in most cases. The last thing I really want to touch on today, Prop 19. So when we're talking, I'm sure you've heard a ton of our other webinars address Prop 19. And today I just want to highlight on a small subset of that legislation, which is this LLC component. So when an LLC acquires the property, it has specific rules that apply to it that dictate when the property will be reassessed for property tax purposes. It can get complicated, but the real takeaway I want to leave you with is that this may mean that you want to buy, if you don't already have the property, you may want to buy the property with the LLC. If you buy the property with the LLC in a transaction that is reassessed, so the property is reassessed when you buy it with the LLC, then you fall under the change in control rule, which is usually more flexible and means that you can hold on to that lower property assessment for longer, but it will vary depending on your specific situation. So I would say the takeaway, just come in first to ask questions from a tax attorney, and then we can work with you to determine what the best course of action for you is. So that's the content we have for you today. I really appreciate you taking the time with us. How can we help? How can you move forward with us? So we can certainly help. Elaine can help from the perspective of prosecuting or defending evictions. We can help give advice on any of the content that she's presented here today. I also highly recommend her webinar next week. It's going to have a lot of great content, so stay in contact with us and attend that webinar as well. We can also help you in the business team here. We can set up your LLC for you. We can help you maintain your LLC. We can provide some general business and tax guidance to best support you and protect your assets for the future and your legacy. So we like to end on some of these slides that just highlight what I started with at the beginning of this presentation, which is, if you haven't worked much with Copenbarger yet, a key benefit of our firm is just our diverse skill set and our wealth of experience. We've been around for more than 45 years now. We have 10 full-time attorneys, now more. We have 2 of counsel, I believe now 3 CPAs. Years and years of combined attorney experience, advanced degrees. We can provide all of the support that you need. Thank you again for sticking with us. This last slide is just some of our contact information. I believe our team has put in an eval or, oh, yep, there I see it, has put in the link for our digital eval. I really strongly ask that you complete this evaluation. The only way that we can learn how to better serve you is by getting feedback directly from you. So if you want different content, or if you loved certain areas and you want us to go deeper on them, please share that in the eval. If there's any way that we can improve in the future for you to better serve you, please fill out that eval now. I'll stay on for a couple minutes. I think we got a couple questions in the chat. And so we'll touch on them in just a moment. I also want to mention that if you're looking for a link or information on, for example, Elaine's upcoming webinar or any future webinar, please check out some of our social media outlets. That's always a easy place to go. Follow them, then you get up-to-date information on all of our events. You can also always just visit our website too. So I'll stay on this slide for a little bit. Go ahead and check out that eval. And Elaine, I see a couple questions for you, maybe if you want to get started.
I sure will. One of the questions was whether the new security law is a state or federal law. This is a state law. The question was whether or not the LLC has to be part of the trust, if you have a trust. No, it can be separate from the trust, but you can also have in your trust your membership interest of the limited liability company. That's something you want to talk to your estate planner, and you want to talk to the person setting up the LLC. Business and tax can help you regarding as to which is the better method. But basically, whether it's in your trust or out of your trust, the concept is that the LLC is a different person, and that it's a fake person. It's a something the law recognizes as a person, and this artificial person has it so that they can only go to the assets of that artificial person, provided that the artificial person has been put together correctly. And that's what we can do for you and help you with that regard. There was a question about whether or not you're working with a property management. If you are working with property management, you expect the property manager to do some of the things that I told you about that will protect you. But as the owner of the property, it's ultimately depends on how well they did their job as to how well you're protected. Just because you have a property management company doesn't mean that you're protected from the liabilities that come about. So if the property manager makes mistakes, then you may end up being liable for it. We advise quite a few property managers. I've done that a long time. But again, it's ultimately your responsibility to see what the property manager is doing, and you listen to them, talk to them, make sure they're taking care of your needs. They will most likely have attorneys that are taking care of that. I believe that was the questions I had, but I'll turn it over to Katherine to see if she has some questions she needs to answer.
Yeah, and we've been getting a great number of questions in the chat and in the Q&A section. So we'll try to. There's a couple more that I think I saw that I'll touch on, and then if anything we miss, we'll try and get in touch with you afterwards, or you can always contact us or email us at info@copenbarger.com. One of them was, okay, so if purchasing out of state, will I need to set up an LLC in that state? Typically, no, you can set it up in a different state. Guidance will vary depending on the state and the recommendation. All states will have different requirements for the LLC. It's I hate to say one way or the other. Typically, we see setting up an LLC in the state where the property is. It's what we tend to do, but it varies quite a bit. And you can certainly have an LLC in the state of California, but a property somewhere outside of California.
I've had
Go
I
ahead.
had one of the questions that somebody has is, what is an example of discriminating against someone based upon the source of income? Well, if their source of income is from perhaps Social Security, or perhaps it's from part of their income is from a spousal support, or it's from a welfare, or if it's those are type of things that people sometimes will say, well, I don't recognize the fact that your father gives you X dollars per year. I'm not going to count that. You can't do that. You have to look at what they say, these are the source of income. And if they can back it up, I don't mean that they can say, Dad gives me X dollars and there's no proof of it. But if they show you that they are getting certain amount in welfare, they're getting a certain amount from spousal support or the like, then you have to accept that. You can't just say, well, I only want earned income. If they're getting interest off of bank accounts, you have to count that too. So those are different examples of type of discrimination based upon source of income.
Another one that I just really briefly want to touch on, living trust versus LLCs, they're just protecting the assets differently, and your living trust will not protect from personal liability incurred for your rental property. So think of them as two separate needs that are not related. Anything else you see in the chat? Looking. Thanks a lot for the participation too. We love questions.
I have one final question somebody's asked. They said, what about a lease and somebody breaks the lease? Are they responsible for terms of the lease until new tenants are found? That's a very complicated question, but basically you can terminate somebody for breaching a lease, and then you can hold them responsible for the rent, but you have certain obligations that go along with that. If somebody has walked out on your lease and they haven't finished paying for it, you have to be marketing it. You have to be trying to get renters in there. There's a lot of things you have to do under the code in order to be able to sue them and say, you still owe me for the months that I couldn't rent it out to somebody else. So I can answer that in a lot more detail directly to you, but I just want you to know there is some liability there. You can get some recourse.
All right, I think we've hit almost all of them, so it's good. Thanks again, everyone, for joining us, listening, participating. This will be posted, the recording will be posted on our website, likely later today, and then also available on our YouTube channel. Please feel free to call us anytime, email us anytime. We're more than happy to set up appointments with you to discuss your specific needs and situation. All right. And with that, thank you.
Thank you.